which is case number 105828, State of Kansas versus Dwight B. Cameron.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm here today on behalf of Mr. Cameron. I request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, my plan today is to talk a little bit about the lesser included offense issue with regard to felony murder, and as time permits, maybe a little bit about the hearsay issue, and of course whatever else the court would like to chat about. The first issue in this case has to do with the failure to give a lesser included offense of involuntary manslaughter in this felony murder case. We all can have a certain level of empathy for Judge Waller in this case, and that Barry came out after the trial in this case and did change the law somewhat with regard to the felony murder rule. But that certainly applies in this case, and so we're dealing with that. And I sort of recognize that with regard to this issue, as I was reviewing this, getting ready, it seems like that I acknowledge maybe the court isn't of one voice on this, or one clear voice. Maybe I would respectfully submit on this. But I think that this is the analytical approach that we should take. We have to decide whether the lesser included offense was legally appropriate, and then determine whether it was factually appropriate.
Okay, then let's jump in. Why is it factually appropriate? And where is there any evidence of recklessness here?
And when we do this factually appropriate analysis, my understanding of the majority of the court at this point is that the test is, had Mr. Cameron been convicted of involuntary manslaughter, would this court have reversed for insufficient evidence? That's the test and Haberline and cases after Haberline that this court has established. And so the answer to the question then, Justice Rosen, is it's not, we shouldn't be looking at, for example, what his defense was or things like that comparison, because that's irrelevant to the question of whether there was sufficient evidence of involuntary manslaughter. And so the question is, assuming, again, I have to take the facts here. I'm not conceding anything on my client's behalf, but taking these facts here is the state's evidence that my client repeatedly struck this child many, many times, eventually causing this child to die. That's the state's evidence here. And the question is, faced with those facts, would this court find insufficient evidence to support a conviction for voluntary manslaughter under those facts? And I submit, of course not. The problem here is the state is really arguing this strongly in this case, but we don't know the state of mind of the person. And the fact that there may be intentional conduct on part of a person does not mean that there's intent to kill, which is a requirement for first or second degree murder. Killing somebody without intent to kill is involuntary manslaughter, or maybe second degree reckless murder. And so that's where the problem here is. This court has said, under circumstances similar to this, that a jury might infer intent to kill, and that, I think, is probably true. But it doesn't necessarily mean or exclude the possibility that a jury could conclude that they have a reasonable doubt whether there was intent to kill, as opposed to somebody acting out in some sort of angry way, or whatever the situation is, not intending to kill, but actually killing. And what is that? That's involuntary manslaughter. If somebody does something knowing, we should all be able to say that you knew or should have known that this kind of conduct could result in the death of somebody, and it did, that's involuntary manslaughter. So even the state in its brief, Your Honor, recognizes that, is making this idea that ordinarily a person, you can infer from a person's conduct their intent, and that's fine, but it's not that it necessarily is the case and excludes the possibility of any other conclusion. And that's your question, is could a rational jury have said, we have a reasonable doubt whether or not Mr. Cameron intended to kill the victim in this case? And if that's true, then there was sufficient evidence to support a conviction for involuntary manslaughter. If that's true, and I think the record makes it abundantly clear that that's true, then it was error to not give the instruction. As I understand this court's analysis and agree with this court's analysis. The turning then is, do you reverse then on that? And that's a distinction between this case and maybe some prior cases, because in some prior cases of this court, there was no request for the instruction. This is a requested instruction in this case, and therefore I'm not dealing with clear error or anything like that. We should be looking at a straightforward analysis. And in fact, I actually, as I thought about this analysis, it seems sort of redundant to me to apply a harmless error analysis when you're dealing with a requested instruction, because you sort of built in the harmless error test to your evaluation of the evidence already. I mean, if a reasonable juror could have found involuntary manslaughter, then a reasonable juror could have found involuntary manslaughter. And so I'm not sure when it's a requested instruction, what additional step the court would have. But that's our position on this, that applying this court's analysis, that it's...
What's the when this do you just automatically get an instruction when it's requested, even though the facts may or may not? It takes rather a speculative, creative view of the evidence to get to the requested factual instruction, to factually support the instruction. Basically, if you request it, you get it.
If the evidence supports the lesser, would support a conviction for the lesser.
And here I'm still having trouble. When you're in conference requesting instructions, what evidence was pointed to that supports the instruction? I just didn't see it, and I don't see it looking on my review of the facts. I don't see where it was in the request where it was articulated what facts support that instruction. So you request it, you get it.
If the evidence... No, I'm not denying that the evidence has to support it. Our argument is evidence of somebody taking an action like this, repeatedly striking somebody, a particular young child, even if they don't have the intent to kill, that they knew or should have known that it could cause death. And that's reckless behavior.
Actually, the evidence was used here to convict him of felony murder. They said he was committing child abuse. Not that he intended to kill, but that he was committing child abuse and that the child died as a result. So the state actually used that absence of intent to kill to get a first-degree murder conviction.
It's a part of the reason for the felony murder rule. That's to be certain. And to try to answer your question, do you automatically get it? I think in a lot of cases, a lot of felony murder cases, at least where there's an issue with regard to intent to kill, then yes. Okay. In a lot of cases, you are, if you request it, going to be entitled to this lesser included offense instruction, because in most cases where there's a question with regard to intent to kill, then the evidence is going to support, assuming that conduct otherwise supports a finding of recklessness, will support that lesser included offense instruction. I can't say for sure in all cases where the only theory is intent to kill. I would honestly answer your question. I think in most cases that I can imagine, the answer still would be yes, because intent is almost always something that you're gleaning from other evidence. And the concern is, do we always know unequivocally without possibility that there's intent to kill as opposed to something less?
Mr. Hodgkinson, this is the part I'm struggling with on reversibility, because it is a felony murder as opposed to a pre-med. I mean, felony murder really kind of excuses the state from proving up intent, doesn't it? Intent to kill.
It excuses this. They don't have to prove intent to kill. That's right.
So I can understand your argument on when what you're saying in essence to me is when there's an absence of direct evidence of the state of mind of the defendant, then it is pretty much virtually automatic that when you're charged with first-degree pre-med that you'll also get some lessers. But when you're convicted, let's say you're right on all that. Let's say we accept that. You start dealing with felony murder here. And in felony murder, that doesn't have to have been proved. So how was your client prejudiced?
But there are different things that have to be proved, particularly, and this is one of the issues that we're talking about in another issue in my brief. It has to do with, for example, causation, temporal proximity. All of these other issues go into whether the predicate felony caused the death and things like that. And so that's a separate issue in my case. And even if you disagree with me on that, the jury is still making findings regarding that. I think we all have to admit that that it is possible for a jury to decide that a death did not occur as a result of, by whatever standard the court sets, the predicate felony. And if that's the case, and that's in fact the whole purpose of Berry, is the idea that there could be lesser included offenses, and for example, in this case, had the jury been given the lesser included offense as requested, then they would have been comparing these things and trying to decide. And even if you reject my claim that there's insufficient evidence of sort of the temporal link between the predicate felony and the death, that's still something the jury would have been considering and could have reasonably said, well, we don't know that it occurred during, if we would really read the instructions carefully, that it occurred during the commission of. So is there an alternative? And if there was a lesser given, then there is an alternative.
Okay, I understand. Thank you.
And can we, what about the legislative changes that have occurred since this conviction? You want to speak to those?
Sure. I think this court has already said that those legislative changes don't apply retroactively, that it would be an ex post facto violation.
What's ex post facto about this? What's the greater sentence that, explain to me your ex post factos.
Well, it's a substantive. It would be a
Doesn't it
substantive
require an
change.
increase in punishment?
That he was entitled, if you agree with me, and as far as Berry says, if he's entitled to the lesser included offense instruction under the law in existence at the time of the offense, then he's entitled to that now. And to the extent that the legislature went and changed and said there are no lessers now of this, one, as this court noted, there's some constitutional ramifications of that, and two, there's no doubt that's changing the nature of the crime to disadvantage, if you are applying it, in this case, to Mr. Cameron. That's it's not a sentence issue.
Right.
It's still disadvantaging Mr. Cameron. That's explicitly why they did it. And they can't do that retroactively.
What's the constitutional disadvantage? I mean, we're talking about lesser includeds, aren't we? There's not a constitutional right to lesser includeds, are there?
Well, this court said maybe there is.
Maybe. Explain to me why there is.
It has to do with
Constitutionally, I mean, this all flows from statutory creations. So why is it why does it implicate the Constitution?
Okay. We haven't briefed this, and if you want to order us to brief that, I'll be glad to do that, but I can't answer your question, which is, I think there is a constitutional issue with regard to the due process clause and the jury trial clause, because if there is are lesser included offenses that are available and appropriate as a matter of state law, then who should decide between them? And it's, under the United States and I think the Kansas Constitution, the jury's job. Under the Due Process Clause, under the Jury Trial Clause of the United States Constitution, and under the Jury Trial Clause of the Kansas Constitution, it's the jury's job to make that distinction between them. And failing to give the lesser included offense interferes with that jury's right and my client's due process right to have an accurate determination of what the offense is in this case. That's my short answer. I could develop it a lot more if the court directs.
Sure you could. Yeah.
Any further questions of counsel? Thank you,
Thank you, Your
counsel.
Honor.
May it please the Court, Assistant District Attorney Leslie Isherwood, appearing on behalf of the state. As opposing counsel did, we will be confining our discussion today to the first issue. To the extent the Court has any other questions with regard to the other issues, I'm certainly happy to address those. The first issue challenges the Court's refusal to issue the instruction for reckless involuntary manslaughter as a lesser included of felony murder. At the time of brief writing, in this case, Berry was the applicable standard. In the interim, the legislature has come along and amended two statutes to indicate that there are no lesser includeds of felony murder and that it is, in fact, retroactive and applies to cases pending on appeal. So it would be the state's position that that being the latest pronouncement of the law, that would be what would control in this case, and he would not be entitled to lesser included offenses. That way, the only mechanism for him to obtain the relief that he seeks is to establish that this is an ex post facto violation, and I would acknowledge that the parties have not briefed this issue, so kind of a surface discussion, it would be the state's position that there is not an ex post facto violation established because the two-part test hasn't been met. Does it go back in time? Yes. But has he been disadvantaged? No. It doesn't affect the crime charged. It doesn't enhance the punishment that's prescribed for the crime, nor does it adversely affect the quantity and the quality of the evidence that's required to establish guilt for the offense
I don't
that's charged.
understand how it can't affect the crime charged, because if you instruct on lessers, then the crime charged is this or this or this, and if you don't give the lesser, the crime charge is just this.
But it doesn't affect the elements of the crime that he's been charged with. It doesn't affect the substance of the crime that he's been charged with. The amendments have not altered that crime specifically in any form.
Essentially, you're saying the prosecution can still choose to, whatever crime they want to charge, and it's the elements of that crime that they charge that are important in the ex post facto violation.
Correct. All that has happened with respect to these amendments is it regulates the steps that are to be employed to determine how he or what criminal statute he has violated, but the actual substance of those statutes has not been changed. To the extent this court determines that the amendments do not apply and that Berry is the appropriate analysis, the state would argue that he also is not entitled to relief under that analysis. Under Berry, a lesser included instruction is given when there is not just sufficient evidence, but whether there is a reasonable probability that the jury would have convicted based upon that evidence. If we're going to look at just the evidence, then any time a person dies, we're going to say, well, that's a lesser included because there are commonalities, because, in fact, a person died. But that borders on the ridiculous to some degree. We have to look at whether it's reasonably probable that a jury would have convicted of that lesser included crime. And when we apply that analysis to this case, we don't get there. The child in this case suffered 20 blunt force injuries to his head alone and 40 to his body. The unrefuted medical evidence was that this was intentional, that there was nothing accidental about these injuries. They analogize these injuries with that would be sustained in a bar fight and in a car accident where the child wasn't even strapped in but was battered about the vehicle. There is nothing accidental about these injuries. Did he die? Yes, he did, and that's unfortunate. But is it reasonably probable that a jury would have found that this was a reckless act? And it would be the state's position that that's not possible under the facts of this case.
Is it the act that has to be reckless? I mean, the intent, the idea is that you intended the act, but what was reckless was the intent to kill, isn't it? Haven't we clarified that reckless doesn't mean that it was an act that happened recklessly, but that it was a reckless disregard for whether death occurred?
It's recognizing the imminence of that danger and then acting in conscious disregard of that danger. And we don't even have that here. There's no acknowledgement that he recognizes that there was a danger. He's basically saying this was just an accident, that I got out of control and I beat this child excessively. He doesn't even argue that he recognizes that. In fact, he says he was shocked and dismayed. That's not a recognition of his recklessness. Again, the facts in this case support only the finding of the greater crime. A reasonable jury would not have convicted of a reckless act in this case. And for that reason, the state would respectfully request that these convictions be affirmed.
So, just to confirm, I guess you don't agree with Mr. Hodgkinson, that Haberline, I think how he phrased it was that he viewed Haberline as saying that if essentially we would have found evidence of involuntary manslaughter sufficient, that we essentially have to approve a lesser included here.
I think that dilutes what we're looking at. I think you have to look at not only the evidence, but whether a reasonable jury would have looked at that evidence and convicted of that crime. I think it's essentially two parts, and I think that's kind of been excised out in opposing counsel's argument.
How does that keep us from being the jury? if we make a determination of what's the appropriate crime to convict of. I mean, you're saying we need to look at it and say, well, the jury should have convicted on this, of this crime because here's the evidence. I mean, why isn't that taking it away from the jury to make that determination?
I don't think it is taking it away from the jury. I mean, if we're essentially looking at this in the position of the district court, and we don't look at it, I guess, in a vacuum. We don't look at it strictly on the elements, but how the jury is ultimately going to view that. I mean, I guess can't really formulate an answer to your question other than it's not. I mean, I guess you would say that with respect to any time that you're going to issue an instruction. Why then don't we always give the full panoply of instructions that are available? Because there are going to be certain situations where it simply does not fit. And that isn't the court taking the place of the jury. That's the court's responsibility to help make that assessment and to apply the law to the facts and determine what's appropriate to give to the jury.
Ms. Isherwood, I just want to make sure I'm clear on your position. I understand your focus on whether a jury would reasonably convict. I understand that you're trying to make sure we don't forget that part of the standard. But here, the evidence that you say makes it impossible that a reasonable jury would have convicted of a reckless crime is the number and severity of the injuries. Correct?
Yes.
Okay.
Anything else?
I think you have to look at how those injuries came to be. I mean, if you're going to say this was reckless, which one of these injuries? At what point was it reckless? I mean, we're talking about a total of 60 injuries in this case. You have to look at the manner in which they're delivered. It's not just their existence, but how it is that they came to be. And it's simply when you get to that point and you look at the act that produced those injuries, that is not a reckless act. That is not accidental. When you look at a child of this size to inflict 60 injuries.
I think we're talking past each other, because if you're going to say that the act itself is reckless, then your argument is very understandable. But if you're saying that the reckless portion means reckless disregard of the consequences of intentional acts, like beating a child, and you disregard the imminence of death that can occur, but you still are intentionally beating the child, then your argument doesn't make any sense to me.
I guess I don't understand where.
Well, you're arguing that reckless is synonymous with accidental.
Because that is pretty much how this court, when conducting analysis of like cases, that's the manner in which, that's the approach it has also taken.
Are you arguing that when we look at the probability of the jury verdict, we're saying that it's unlikely that they would have ever moved past finding that there was child abuse and felony murder as a result of child abuse?
Based on the facts of this case?
Yes.
Yes.
Or are you saying that we would find that it's reasonably improbable that the jury would have convicted of reckless? I understand what I'm saying. Are we talking about it at the first level, that they would never consider it, or are we saying that if they consider it, they wouldn't find a reckless murder?
I think it's more the latter. I think basically the way this court has interpreted lesser included is I think it's more the latter.
And that's the way you're arguing it as well?
Yes.
Because I wasn't sure if you were stopping at that first step. Or...
No.
And the defense in this case was that, I thought it was that I didn't, if these severe injuries I didn't do because all that I witnessed was him falling out of bed.
It was kind of a multifaceted thing. It was a fall in the tub or from the toilet. It was possibly his younger and older sibling, or it could have been the mother. So there were about 3 different things that were going on. There was evidence presented that at the time that the witnesses came in and first made contact with him, that it was an explanation for 2 different falls. There was evidence that came in that he said, well, perhaps, it was inflicted by wrestling about with a sibling or arguing with a sibling. And then there were also some intimations that perhaps it was something that was inflicted by the mother before she had left that day. So there are a couple different things going on.
Counsel, when the defense asks for a lesser included offense and the court is struggling or trying to decide whether to give the instruction or not, the court has to look at a certain amount of evidence before making a decision, correct?
Yes.
And from whose perspective is that viewed? Is it the light most favorable to the requesting party, in this case the defendant?
Yes.
And so it's your position that even looking at the evidence most favorably to the defendant, the lesser included instruction still should not have been given?
That's correct. Again, if there are no further questions, we would ask that these convictions be affirmed.
Any more questions of counsel? Thank you, counsel.
Yeah, I just had a couple points on rebuttal. One, and it's not really a rebuttal, but I just wanted to follow up with Justice Rosen's question that I don't think it matters with regard to this ex post facto, whether it's constitutional. Any disadvantage, even if it's a statutory disadvantage, would be enough to prohibit the legislature from doing something like this retroactively. So I want to be clear that I don't think that matters for the purpose of this.
Any disadvantage? Can a procedural, any disadvantage, then you're...
Any substantive disadvantage.
Okay.
Substantive disadvantage. My colleague noted that her belief that it's not reasonably probable that a jury would have come back with a involuntary manslaughter verdict in this case. That's not the standard. It's not her standard, and it's not your standard to determine to sit as a super jury and decide what's reasonably probable in a case like this where the lesser was requested. The standard should be, is there any evidence on which the lesser would be supported under the evidence?
For which a jury could reasonably convict, I think, is a statutory language.
Any jury could reasonably convict. Not whether it's probable,
I understand.
even if it's the 1 in 100 jury. And Justice Lukert, if the lesser had been given in this case and the jury had been properly instructed, they would have been instructed, consider all of these things. You can convict of felony murder, you can convict of involuntary manslaughter. If you have a reasonable doubt between them, you can only convict of the lesser. So a jury, properly instructed jury, following the instructions, at least would have considered the relationship between those things. Why not give the jury the full panoply of lesser included offenses? To the extent that it's not reasonably probable that they will convict of the lesser, what's the harm? Why not let the juries do their work, as opposed to having judges make these determinations about what judges think are the best possible verdicts in these cases?
So what's the purpose of the statute? Why not just say, what's the function of the statute that gives the court some discretion or actually requires the court to look at evidence and then give the proper instructions? Why have that statute?
When you're dealing with lesser included offenses, to the extent, there may be some lesser included offenses where they're like voluntary manslaughter, where there's an additional...
Why not instruct on battery in this case?
Battery's not a lesser. It's not legally appropriate.
Okay.
So you don't give legally inappropriate instructions, but factually appropriate, that should be a jury's determination. To the extent that my colleague is right, that a reasonable jury wouldn't do this, then they won't. But if a jury did do it, and they would have done it, but they were prohibited because the judge...
My trouble with this, Mr. Hodgson, it really just, if you request it, then the trial judge just has to sit there and fantasize and speculate what can I imagine could be created from this evidence. And basically, it's just, once you request it and facts are established that's within the realm of possibility, then you give it.
Then let the jury make the decision.
So
The jury is
essentially what you're
charged to
saying
make.
is there's really no screen, there's no filter, no nothing. As long as there's something that I can imagine, that I can speculate, you get it.
Yeah.
You don't speculate about the evidence, you speculate about the theory. The evidence has to be there to support it.
Evidence has to be there, and in cases where you're dealing with, certainly where you're dealing with like first-degree premeditated murder versus second-degree intentional murder, there's always going to be evidence of second-degree intentional murder. There's always going to be a question the jury should be making the decision about whether or not there's premeditation, not a judge. In
I
every
understand.
case,
So
every
once
single
you,
case.
this is not this case, but once you charge and prove, or there's evidence of premeditation, then basically, if someone requests lesser included based upon that, the finding of premeditation, you can create, basically you get every lesser included.
Every lesser that is supported by evidence of premeditation. Yes.
And that would be short of the defendant making a statement, yes, I intended to kill the victim.
Yeah, of course. I mean, we always have,
Anything less than that, you would get the lesser included instruction.
maybe even in light of that,
Right?
because the jury still has to determine, just because a person says that, doesn't mean the jury has to even accept that. But we should be having juries make those decisions, not judges. This case is just a good example of it.
Any further questions of counsel? Thank you, counsel.
Thank you, Your Honor.
Thank you both for your arguments this morning. Court will take this matter under advisement. This time, the court is in recess for 15 minutes.